Thank you, counsel. Next case on the docket is Olsen v. Olsen.
Good morning, Your Honor. I'm Jim Gressler. I represent...
Wait a second, Mr. Gressler. Please calm down a second, if you will.
I'm Jim Gressler. I represent the former husband who is the petitioner below in the supplemental petition. These parties were originally divorced by a final judgment that was rendered in December of '96 as amended after rehearing in February of '97. In that judgment, the former wife was awarded permanent periodic alimony of $450 a month, attorney's fees, and there was an equitable distribution. At that time, the former husband took an appeal to this court, and this court reversed the award of attorney's fees, upheld the award of $450 in permanent periodic alimony. We almost won at that time, but not quite, because the court stated, although the award of permanent alimony in this case is a closed question, we affirm on the basis of Conacris. At the time of that original trial, the former wife was not working, and the trial court found that she was unable to return to her job as a sales clerk at J.C. Penney's because of various physical disabilities. Former husband filed his supplemental petition to terminate his alimony obligation in March of 2004. He had turned age 65 in February of 2004 and was 67 years old at the time of the trial on this supplemental petition. At the time of the trial, his income, and the court found, and that's not in question, was only $610.50 Social Security, and that was reduced by his Medicare supplement down to $522 a month. The trial court reduced his alimony to $200 a month, found an arrearage of $460 because he had stopped paying at the time that he filed. The court said you got to pay that at the rate of $50 per month or $250 total until that arrearage was paid. We have raised two questions on this appeal. That is, whether or not the findings of the trial court with respect to the wife's income or money she had available to meet her needs is supported by competent, substantial evidence in the record. And the second issue is whether the trial court abused its discretion by failing to terminate the former husband's alimony obligation rather than reducing it. It's interesting to note in this case that in March, right after that amended final judgment, the wife returned to full-time employment, and the husband never filed a supplemental petition to modify or terminate that alimony until after he turned age 65. Now, the problem here is the court's findings. The trial court found that the former wife had W-2 gross income of $1,472 a month, $8.50 an hour. Well, the court simply evened it up at $1,472. But the next finding of the trial court is not supported by the record, the wife's testimony, or the financial affidavit that she filed. The wife had been a good manager of her money. She purchased 2 annuities. And contrary to what the wife's position is on this appeal, those annuities had increased in value even though she had been drawing $1,004 a month from those annuities since 2002. Now, the
Is
court-
there a difference if a party takes their equitable distribution money and puts it into an income-producing medium or into a non-income-producing medium when it comes to a subsequent modification proceeding? As I understand it, these annuities were bought with equitable distribution monies, correct?
That's correct, Your Honor.
If she had put it all into a house, and the house was sitting there appreciating, but it wasn't throwing off income, do you treat it differently than if you put it into an annuity and it throws off income?
Well, it depends on the situation involved here. Now, our position is, and the Supreme Court has said, that it is a substantial change in circumstance that may or may not justify a reduction or a termination of alimony after a person attains the normal retirement age of 65. The concept and theory behind that is that once a couple attains that normal retirement age, they're going to learn how to live on less income or less cash flow into them because the both or one of them is going to retire, whether they're divorced or not. So I don't know that it's relevant here. In certain cases it may be. But what we have to do here, and the trial court found, and it's not in dispute, that the retirement of the former husband was a substantial change in circumstance. And under Pym versus Pym, then what we've got to look at, since the trial court found that the former husband's only income was Social Security, whether or not terminating that income is going to place the wife in a position of peril. In other words, is she going to become destitute? Does she really need this money? So we've got to then look at what her cash flow is, regardless of the source of that. And that's why I say it's not really relevant in this case. And what the court did, if you look at the wife's financial affidavit, she said she was drawing $1,004 a month. Now, somehow the court interpreted that to mean that she had only drawn $1,004 over a 5-month period and found that it was $200 a month. But clearly, if you read her testimony, she said no, she was drawing $1,004 a month from those annuities, and really it wasn't reducing the value of those annuities because we offered in evidence the value of those annuities even after she had been drawing that. So we've got to consider that's money available to her to meet her needs as to whether or not she is placed in a position of peril, financially destitute, etc.
What does the evidence show in terms of whether any of that withdrawal was principal?
There was no testimony other than the fact that the evidence that we introduced showed that those annuities had increased. So I would assume that you would reach the conclusion that it must have been interest on those since those annuities increased even after she had been drawing $1,004 a month. So, and then
the date of the value of the annuity that she introduced into evidence.
The only information we had that the wife gave to us was 2002 to 2003 to 2004, I think it was. And they had increased in value even though she acknowledged that she had been drawing. So essentially, the wife also, since the entry of the final judgment, started drawing $442, and that was estimated because her position was that she didn't need to file up-to-date financial affidavit. She filed one in 2004 and never updated it until it came time for the court to determine whether or not the trial court below was going to award her attorney's fees. And it's interesting, if you look at those two financial affidavits, all of a sudden the land that she owned became worth 1/10 of what it was when she filed her original financial affidavit.
Is the standard about whether the spouse is going to be placed in financial peril limited to an income analysis, or does it encompass an asset analysis as well?
I think it encompasses both, and here the wife had net assets of $644,000, net assets.
So, for example, if the spouse had bought a house free and clear instead of an annuity, arguably she could, but she had no income, she could be required to, for example, get a reverse mortgage and start getting money out of the house to live on because she's not in peril of poverty because she has that asset she could look to?
No, I do not think that would be the case. I think the court would say, okay, you purchased this home, you have the right to live there. That's the way you were living when you were married to this individual. But essentially, she had a home, a completely paid for home. She had a car that was completely paid for. So she wasn't in a situation where she couldn't afford to live the lifestyle that she had lived. The trial court, I don't know where the trial court was coming from when it looked at what her cash flow was, because the trial court said, okay, now we're going to deduct Medicare and Social Security from the total amount of the gross income or the gross flow that he found to her. And certainly you don't pay Medicare and Social Security on Social Security benefits, and you don't pay it on annuity distributions. We pointed this out in our motion for rehearing, so we haven't lost the right to argue that, but the court summarily denied the motion. So under the circumstances, if you look at what she had available, as we pointed out in our brief, she had $1,473.33 a month coming in from her employment. She had $442 a month from her Social Security, and she was drawing down $1,004 from her annuities without reducing the value of those annuities in accordance with the evidence. If you subtract her FICA and Medicare from her earned income only, and you go to the tax tables as the court did, if in fact all of that was interest, her taxable monthly income would have been, she would have had to pay $264 a month. So she would have had monthly net income of $2,692. Now, if the annuity payments are not taxable, then it would have gone down to $2,542.29. Under the circumstances, what the court found with respect to her income is not really supported. And clearly, in the final judgment that the court rendered, there's an error, because the court said the Social Security was $422, but if you look at his total of her income, he really used the sum of $442. Now, after you look at what her cash flow is to meet her needs, then you've got to look at what her living expenses are. And she's expected to be able to maintain the same lifestyle that she always had. She indicated, and as I said, the only financial affidavit she filed prior to the trial showed that her living expenses were $2,803.70 a month. However, at that time she had a car payment of $340. Now the car is paid for. She also was paying substantial amounts for health insurance. Now she's on Social Security and Medicare, and she's paying a Medicare supplement of $89 a month, $38 a month for supplemental coverage, or a total of $172, amounting to a reduction of $307 a month in her health expenses.
Mr. Dressler, isn't the only aspect of your appeal that's outside the ambit of CONACRIS the question of whether the trial court correctly calculated her income?
That's correct. Her income and her expenses.
Tell me again what's wrong with the expenses?
Well, the expenses, the court did not deduct from her expenses the fact that she no longer had a car payment. Her car was paid for. The court didn't properly deduct the amount of her savings in health insurance. But what the court did if you look at the final judgment, the court found that all those expenses that she listed under child care should have been deducted. I don't believe the evidence would support that because she testified that really those were gifts, and I think she would be entitled to make gifts to individuals. I did not deduct those expenses. I simply deducted those items that she no longer had based on her testimony and came up with the fact that she had a surplus. Her monthly expenses, after we deducted the $340 for the car payment, the $307, a reduction in medical expenses. I didn't even deduct the medical expense that she was showing outside of her insurance as the trial court did. And I did deduct the $90.42 that she was no longer paying for long-term health care. And now she even has sufficient income, so all of a sudden she's taken on the nice condition of supporting a foster child at $21.67 a month. So it's clear that this woman is not in peril of financial ruin. And under the circumstances, I think that's what you've got to look at here. The question was, okay, did the husband convey everything? Was the wife earning all this money and covering up for the husband? If you look at the testimony, the total income of the husband and wife, adding the husband's Social Security to what the wife was earning, was less than the gross income of the former wife if we take into consideration those annuity payments. So it's our position that under the circumstances and under the concept of PIM versus PIM, that retirement is a substantial change in circumstance, and it should be justification for either terminating or reducing, based upon the circumstances of the alimony recipient, that alimony award. So we believe the court used its discretion in reducing it to $200 a month, after finding that the husband's only income was $400 and some dollars a month from $522 a month from Social Security, and there's nothing in this record to show that the former wife was earning substantial sums of money, because their joint tax returns were in evidence showing what their income was. I'd like to reserve the rest of my time.
Got about 3.5 minutes left.
I'm Paul Goldman, representing the former wife, the athlete, before this court. The PIM decision did, in fact, create a new departure regarding permanent alimony. Alimony is no longer necessarily forever. It eliminated the need for the retirement to be involuntary. It also allowed the retirement to be considered even though it was a contemplated event, provided the person reached age 65. But a careful review of the PIM decision also indicates that all the circumstances must be considered and the retirement must be reasonable. The husband initially contended in his modification petition that he had suffered medical reverses. However, the record clearly shows that he underwent back surgery. He was restored to health, apparently. He made 2 motorcycle trips to Florida from North Carolina following the final judgment and prior to the modification trial. I was able to go to his wife's real estate office and function there. So his health is not an issue as initially contended. Secondly, contended he had significant medical expenses, I believe, owed to Mayo Clinic in conjunction with his back surgery. The evidence now reflects that all of these expenses were paid for his Veterans Administration benefits. So all that remains is the basic finding of PIM that at age 65 the court can consider retirement to be reasonable and can...
And did the court make that determination in this case, whether or not his retirement was reasonable?
It made no specific finding. It did not. But the record shows that he basically retired in 1999, 3 years after the final judgment was entered. He stopped functioning in the real estate field where he had been an agent or a realtor for over 13 years. He simply laid it down. He depended upon his new wife, with whom he lived for a period of time before their marriage in 2001, and admitted he
What's the relevance of an early retirement? Does that mean he can never, if he retires at 60 and the court said he shouldn't have retired till 65, does that mean he's got to pay alimony forever because he chose to retire at 60 rather than wait till 65?
No, Your Honor, maybe I misstated it. In his mind, he retired because he stopped trying in 1999. He contended that he was no longer working at his chosen field. So we consider that as of 1999, he was no longer trying. In 2001, he chose early Social Security benefits at age 62, another step in his path to just not paying alimony. And then finally, upon reaching age 65 in the spring of 2004, he filed a modification petition. But this was a plan on his part. It's obvious from the evidence. The wife was frugal with her equitable distribution monies, and the court stated it correctly. That if someone receives benefits from equitable distribution and invests them wisely, the court should consider that this is simply a financial decision that someone should make to support themselves. The record shows that the annuity purchased by the wife was basically a single premium annuity from which she has had to withdraw some $1,000 or just a bit more per month for living expenses because of enhanced...
How did she testify then that the asset continued to grow?
Because this is an annuity, Your Honor.
I mean, if it's a depletion of the asset and she's continuing to draw down on not only the income from the asset but the principal as well, why would she testify that it continued to grow? How could that be consistent?
There is no income from this annuity, we contend. The annuity, if the market is favorable, simply increases in value.
But she said that, didn't she testify that she habitually received approximately $1,000 each month and that the asset continued to grow?
I believe she responded, Your Honor, that the asset had a greater value at the time of trial than it had initially. However, that means that the market was favorable and that the level of the investment was high enough so that hopefully under her annuity contract, when she was eligible to draw the funds, there would be sufficient funds in the annuity account to pay the agreed benefit to her.
So you're saying that she wasn't withdrawing anything from this annuity account or this annuity fund? I mean, it was just there growing and...
No, she was making withdrawals because she had no funds. I think it could be likened to withdrawal of principal.
Was it about $1,000 a month?
That's correct. That's correct.
But despite that withdrawal, she said it continued to grow.
Because the market was favorable at that time, Your Honor, yes.
I have one other question. You talked about whether the retirement of the husband was reasonable. Isn't that basically, although it may not be explicitly stated in the final judgment, isn't that an implicit finding by the trial court because he did reduce it some?
The court did find on one hand that the basic element of finding a change of circumstance was reflected, the fact that he turned age 65. That's correct. And then the court did not use the term reasonable or unreasonable, and our position is it's on the record constantly that it was not reasonable, that the husband had a plan again from
The trial court specifically made a statement or a finding that it was not reasonable?
There was no, Your Honor, there was no ruling upon that particular issue. No
Either
ruling.
in writing or orally.
I do not recall that.
I mean, that gets back to my question. Isn't it implicit in the final judgment of modification that the trial judge really thought that the retirement was reasonable and modified it to a certain extent?
I don't believe so, Your Honor. I believe that the fact that the court continued the alimony, even at the very small amount of $200 per month, is a recognition not only of the possible peril of poverty of the former wife, but also reflects the fact that this was not reasonable on his part. My client was still employed at the time of trial, although she had undergone many surgeries, knee surgeries and other orthopedic problems, and had some massive medical expenses building. She was still employed at some sort of living facility even though she was at that time 66 years of age, whereas the husband again laid it down in 1999 and then contended all of his income consisted of Social Security benefits. I'd like to point
Is the
out,
standard correctly to be applied is possible peril of poverty?
yes, I feel it is. If it's
Does
implicit,
that standard encompass an analysis of just income, or does it also encompass an analysis of assets?
I think the Penn decision indicates that the court can consider, as one of its considerations for modification of a permanent alimony, what assets were owned at the time of the dissolution and which were accumulated thereafter. And I think that's that's a salient point. If my client each party received approximately $497,000 in 1996 from equitable distribution. The husband's has been dissipated. He could not.
Well, opposing counsel, I thought I heard him say that if we can consider the assets at the time of the dissolution and subsequently acquired, that she had assets of something around $644,000. Is that correct or incorrect?
That's a bit high, but it's
Somewhere in that area?
I think it's a bit less, but not totally off the mark. But again, she invested wisely. The husband gave some $60,000 to his son as a gift.
So despite the fact that she has, assets that fall within that range, approximate range, she's still in peril of poverty?
Certainly feel so, because a good part of those assets, Your Honor, are in her home, a non-liquid asset, and in some real estate in North Carolina, undeveloped real estate. So her liquidity is significantly less than that. As I recall,
What if it was $2 million? But she didn't. It was in real estate that continued to grow, and as Judge Palmer, I think, was trying to ask before, or she lived in a home that was worth $3 million. That wouldn't factor into the.
Well, of course, that goes to the extreme. I realize the question,
Right.
The reason for your question. Again, it's a possibility that would indicate be some indicia of an ability to earn income from it and such as that. But if someone is living in their own home, modest residence, then that certainly doesn't give them the ability to pay the medical expenses or to pay the shortfall.
So is there a line of demarcation in your mind? If the assets equal a certain amount, then we don't say that there's peril of poverty, but if it falls below a certain amount, or $644,000 to me is a rather substantial amount of assets, but it may not be to you. I don't know.
No, I think I wouldn't argue, Your Honor.
So is there a line somewhere that we draw that if you accumulate so much, well then that's kind of the cutoff point, or?
There's no bright line. There's no bright line. I believe the record reflects that my client's liquid assets, which were invested in an annuity and a small money market account. The money market account was the only source of her interest, small amount of interest. The rest was withdrawal of principal from the annuity. But she had about $300,000 in liquid assets. Now, certainly, and she testified at the trial that her family had great longevity, and she anticipated living 30 years or more. That amount, at $1,000 a month or even more, if her medical condition continues to deteriorate, can be consumed very quickly. Simply because someone has an asset and the number lights up someone's eyes doesn't necessarily mean that.
Is there a set definition of peril of poverty, and is there have the courts established definite factors that we need to take a look at to arrive at the determination whether there's peril of poverty or not?
I've read no definitive bright line statement, Your Honor. I feel it's related to the health of the recipient, the ability of the recipient to earn income, the expense needs of the recipient, such as for medical expenses as in this action. I think it's an accumulation of factors which indicate that at some point in time, anything that's been accumulated is going to be dissipated and simply paying for medical expenses and living expenses. And in this case, of course, the monies were being used in part from the annuity because she was receiving no alimony. She received no alimony since 2001. There was a small accumulation which was paid to her on a negotiated basis in the North Carolina courts to pay in part for the delinquency. but there was an arrearage in alimony since 2001 because not a cent had been paid, whereas the former husband could not explain what happened to some $145,000 which he received in a discounted payment of a mortgage receivable. My client received the same amount. The assets were basically shared equally. He couldn't explain those funds. He made gifts to his son. So the fact that he can now state, I have no assets to speak of, really should fall on deaf ears, because my client was frugal. My clients continued to be employed.
Well, I don't understand opposing counsel's argument to be that he had the ability to pay. I hear his argument to be she didn't have the need. It doesn't matter what his income is unless she had the need.
If I may address that briefly, Your Honor.
And specifically, if you would address opposing counsel's argument that the trial court got some of the expenses wrong because it used an outdated health insurance figure and it used the car payment figure when there was no longer a car payment.
Your Honor, we would respectfully submit that even using the net monthly income of the wife as determined by the husband and reflected in the brief, $2,692, if the annuity is deducted, because that's a drawdown of principal and that is not income, the resulting amount is $400 per month less than the husband's determination of her expenses.
If we determine it's proper to include the annuity as income for calculation of her needs, then you lose. Is that correct? That's the controlling issue.
It may be a factor. I don't think it's a controlling factor when the court found and specified that she remains in peril of poverty because of her medical conditions, her ongoing surgeries, the fact that she's spending more and more to simply pay for her medical needs, and plus the fact that she's drawing down the annuity because she's the principal, because she's not receiving alimony. So as a result, the peril of poverty is there. The possibility that she'll, I guess, be awarded the state is the old case that's used to.
Was there specific testimony that she was specifically drawing down the principal as opposed to, drawing out what was accumulated as income?
Your Honor, the exhibits which were offered shows that the money she received were withdrawals.
Right, she was withdrawing.
No,
but did she specifically testify that, excuse me, that it was the principal that was being reduced as opposed to the income?
I don't know if
you call it income from purposes of...
I don't know if she used those terms, Your Honor. She simply indicated that she had a regular system of withdrawals. And I would submit that if, in fact, this was income, the amounts would not have been identical. This was a plan she had to withdraw, I believe, $1,004 a month. That isn't necessarily the income she would earn each month. And I believe the record also shows from her annuity statements that the amounts which she receives are shown in the parentheses as being a negative amount each month, which shows that these monies were being withdrawn and were reducing the value of the annuity, and in fact was not income.
Isn't there a math miscalculation in the final judgment? Because I understand both of you to be saying she drew $1,000 a month from this annuity, and the final judgment says there was $1,000 in annuity distributions for two annuities. Through 5 months, there was $1,000. Through 12 months, that would be $2,400. This is an additional $200 income a month. Isn't that a mistake? Because wasn't the number 1,000 a month, not 1,000 over 5 months?
I believe it was, Your Honor.
Isn't that enough that it needs to be reversed so the trial court can address the fact that he thought it was $200 a month and it's actually $1,000 a month? I
don't believe so. I think the judge was trying to make some extrapolations and simply misstated. But the uncontroverted evidence, basically the testimony.
Well, he used that $200 a month to determine what the wife's total gross income was, right? So he determined that the annuity distribution should be treated as income, correct?
Well, if it is to the extent of $200 per month, that argument could be made. But
he didn't determine that 20% of the distribution should be income. He decided that the distribution should be income and somehow messed up the numbers and thought it was only 200 when it was 1,000, right?
I think that's closer to the facts, and I believe that he was simply making a comment on the record But I don't think his logic was entirely consistent, but it doesn't alter the fact that both my client's testimony at trial, uncontroverted, plus the annuity documents show that this was simply an amount she was withdrawing and did not represent earnings on the annuity.
Oh, but he did a calculation of her net income, which was clearly wrong, correct?
If, in fact, he only attributed $200 per month as the monies received from the annuity, that would be correct.
Well, if he made a miscalculation on what the net income is, why doesn't it have to go back so he can look at what the accurate net income is and then determine based on that whether or not the alimony should be changed?
Well, simply our position that the result should be the same because of the peril of poverty attitude, or rather factor, the fact that the alleged retirement of the former husband was not reasonable, and based upon the husband's own calculation of her income, she still has a deficit. She still suffers a deficit each month, which the court also found. The court actually found a slightly higher deficit per month, some $500, and if you utilize the former husband's figures as to her net income and her expenses, what he feels they should be, they can be justified, his figures yield approximately $400 per month as the deficit. And again, I don't believe the court divided the baby here and made a Solomon decision by finding, well, the husband has reached the benchmark of 65 years, so maybe this is a reasonable retirement. Maybe shouldn't have to be employed any further and be someone else's beck and call. So I'm going to recognize that benchmark and provide some benefit to him. I'm going to reduce the alimony from $450 per month to $200 per month, a 55% reduction. But I'm going to find that the former wife still requires some funds, even though it'll be a paltry amount, in order not to fall in the peril of poverty. And again, I submit that the wife has attempted to utilize her assets.
That's a pretty thin peril of poverty. If we're going to say that the trial court's award of $200 is going to keep her from crossing the line, I mean, it's a pretty thin line.
I realize, Your Honor, but the factor is that the total award was only $450 per month, so there's not much spread there to deal with. In order to give some relief to the husband, just to recognize he reached age 65, there aren't a lot of dollars to deal with. And this wasn't a husband who suddenly found, I've worked very hard until age 65. I have invested well, and I want to lay it down. I would have retired had we remained married. That's the constant argument we hear. I would have retired anyway. He basically retired in 1999 and only made it official when he filed his modification petition in 2004. He has nothing, so he contends, although so much in the record about he and his present wife's rental property investments, all from properties which he owned before he married her. But in all events, this isn't a case where he simply didn't want to be bothered any further. He planned to retire in 1999, and he attempted to effectuate that plan.
Thank you, counsel. Your time's expired.
Thank you.
May it please the court, let me suggest essentially the court gave her $200 a month in alimony. If we add in the $804 a month that counsel has admitted was erroneous and eliminated by the trial court, that means now she's $600 over and above what she needs to stay out of the perils of poverty.
Mr. Gregory, the problem I have is, I guess, my ignorance of annuities. But I'm not clear from this record just exactly what she was getting.
Well, she testified that she was drawing $1,004 a month, and even though she had withdrawn that, the value of the investments in that annuity had increased to the extent.
Well, that doesn't make it income, though. I appreciate that income is what we have to look at here. We don't look at the appreciated value of assets. We look at income. Well, indulge me. Assume that's where I'm going. Then how do I know that this that this $1,004 a month was income?
Well, we know it because the evidence shows that even though she had been drawing that down, her annuities were worth more now than they were when she first started drawing it. So that means that the interest or the increase in value of those securities surpassed the amount that she was drawing.
But
And
doesn't that go
would be-
back to Judge Palmer's earlier question? Suppose she had a house that was worth $300,000 and on a particular day it was worth $350,000. Do we count that $50,000 as income?
Well, I wouldn't count it, but when it's in the form of interest, and that's what it is.
We don't know that it's interest. All we know is that there is an investment that on Monday has one value and on Friday has another value. But I don't necessarily see that as income. I see it as an appreciation and a value of an annuity contract. And making the distinction between the appreciation and value and income is what I'm having trouble with. I'm not sure that the record explains that to me.
Well, she would have to pay tax, and the court found that she was paying tax on the amount that he found that she was withdrawing. So I assume the court found that it was interest, because if it's not interest and you're simply drawing down what you put in, you don't pay income tax on it. But this is...
Let me use a simple example as a follow-up to Judge Griffin. Let's say instead of annuity you had 1,000 shares of a particular stock. Now, as I understand it, if the stock throws off a dividend, that dividend would be considered income. But if the stock doubled in price and you sold off some of it because you needed it to live on and now you only had 900 shares, but it was worth more than your original 1,000 shares, it wouldn't be income for the 1,000 shares you sold off. It would simply be appreciation that you've cashed in, right?
I think we're arguing something that really is not relevant here. The issue here is whether or not cutting off this $450 or $250 a month is going to put her in a position of poverty, and it's clearly not going to do that, because I'm looking at what she has in the way of cash flow to meet her needs.
What's the remedy you're seeking from us? Do you think this should go back for reconsideration by the trial judge, or do you think this court, as a matter of law, should determine that the alimony should end?
Well, let me suggest that when it came time to determine whether or not the trial judge was going to award fees, he did look at the fact that she had $644,000 in assets and said no fees. I suggest that if it goes back and the court finds that he committed an error of $800 a month and only gave her $200, then the court would terminate it. So as a matter of law, I'm suggesting that this court should say the court abused his discretion and should go ahead and terminate the alimony, because clearly she's not in peril of poverty.
I have one other question. You indicated that the $1,000 that she was withdrawing from the annuity she declared as income on her tax return, or not?
That's what the court said that she did, and the court found that that was taxable as income to her.
Thanks, counsel.